Hello, this is Linda Solash-Reed speaking to you today about advanced directives. Thank you to the Orange County Bar Association for making this educational video possible. What is an advanced directive? There are advanced directives by some name in all states. For this video, we're going to be talking about the Florida specifics. Florida statute says that an advance directive is a witnessed, written, or oral statement that expresses your wishes about any aspect of health care or about health information. In Florida, we have a fundamental right to self-determination of our own health, as long as we are competent adults. We also have the right, while we're competent, to plan for these healthcare decision-making in case we ever become incapacitated, or in case we either choose to receive assistance with healthcare decision-making or information gathering, even if we are not determined incapacitated. These documents that we're going to discuss can be changed by a written revocation, by creating a new written document that revokes the previous one, physically destroying the old documents, or stating verbally that you revoke the document. Also, if you were married when you signed an advance directive and then your marriage is dissolved, your ex-spouse is no longer allowed to serve in those capacities unless the document itself or your dissolution of marriage specifically allows your then ex-spouse to continue to serve in the role. We have some protections that if you sign an advance directive, that this does not affect your life insurance. And if a healthcare provider carries out your wishes according to your advance directives, that healthcare provider is granted immunity from any civil or criminal liability as long as they are carrying out your wishes. Now, suppose you are in a healthcare facility and because of their religious affiliation or other affiliation, they are unable or unwilling to carry out your advance directive. They have a responsibility to try to transfer you to an equivalent healthcare facility that will be able to carry out your wishes. Okay, so I've spoken a good bit about advance directives. What are these things specifically? First is the designation of healthcare surrogate. Again, start with the technical aspects. It must be signed in front of two witnesses. The person you're naming to serve as your healthcare surrogate cannot be your witness, a witness. And at least one of the two witnesses cannot be your spouse or a blood relative. In these situations, we suggest and you are authorized to not only name one healthcare surrogate, but also an alternate in case the first one is unable or unwilling to serve. If you are unable to physically sign your name to this document, you can direct another person to sign for you. So what does this document say, or what does it do? Your healthcare surrogate has the ability to stand in your shoes and make those healthcare determinations on your behalf, whether it's consenting to treatment, declining treatment, getting information, getting a second opinion, all those things that are required when you're dealing with a healthcare situation. The standard they're supposed to use in Florida, if they know, is to make the decisions you would make if you were able. We're going to come back to that point towards the end. Another advance directive is called a living will. A living will is a document that says that if you have a end-stage condition, a terminal condition, or if you are in a persistent vegetative state, your treating physician and one other doctor say that there is no reasonable medical expectation of your recovery from whatever it is you are suffering from, you can say that you do not want extraordinary measures taken to prolong your dying process. Typically, that means things like putting you on machines, hooking you up to a ventilator, feeding you or hydrating you, not through your mouth in the normal manner, but through a tube. Okay, these documents are meant to express your wishes. So while my brief summary was, let's say, what the standard living will says, it is definitely a document where you need to express your personal wishes to the attorney who is assisting you with drafting these documents. One great example here is as we are seeing the COVID-19 pandemic explode before us, perhaps if you had previously decided that you never wanted to be put on a ventilator, you might reconsider if you are hospitalized with COVID, and a ventilator may be a way to allow your body to heal. So in any case, think carefully about what you want to put in writing and ask your attorney to make adjustments to express your wishes. The statute makes very, very clear that allowing us the choice to make healthcare decisions for ourselves does not in any way condone or permit euthanasia or mercy killing. That is not allowed in Florida. Also, it is very clear that if you request that treatment be withheld or stopped, or your healthcare surrogate makes treatments stop or declines to authorize those treatments, that is not the equivalent of suicide. And the reason that's important is primarily in cases of life insurance where there is a bar on collecting in case of suicide. So, why bother to put your wishes in writing? First of all, because you never know. That's the biggest and not a very technical legal answer, but we never know when illness is going to hit us. Again, these days, mid-pandemic, it's become ever more clear to us that the unexpected can happen. But more to the point is you want to make sure that the people you trust and you want to make those healthcare decisions are the people who will be there for you in your time of need. The Florida statutes do say who would step in to make decisions for you if you do not put your own wishes down in writing. In Florida, this person is called a healthcare proxy. I have to again note that the terms are different. In some other states, a healthcare proxy might be the person that the individual designates. In Florida, just keep in mind that proxy means the statute. So I won't go down the whole list, but the first person on your list to make decisions, if you don't specify who you wish, is a guardian if you have one. your spouse. So far, that seems somewhat logical to most people. Then you go to the majority of your adult children, to a parent, to the majority of adult siblings. There can be many cases where the people who would step in as your proxy are not the individuals best suited to make those decisions for you. So I'm going to close with what may be the most important part of this whole discussion. Remember when I said that the person you designate as your healthcare surrogate, their first responsibility is to carry out your wishes, the wishes that you would want carried out if you were able to express them at the time. Your healthcare surrogates, your family, your loved ones, and friends, they need to know what those wishes are in order for this whole system to work as it is intended. So, have the hard talk if you haven't already. Tell your friends and family what your wishes would be and ask them. Ask the ones closest to you who you may be called on to act for them in this capacity. Have the talk. It may not be a pleasant or fun experience, but honestly, if you or your family and friends are ever in the position of having to make those difficult decisions, it will be immensely helpful. Anyhow, I thank you for your attention. Again, Linda Solash Reed, and thank you to the Orange County Bar Association.